So joining us now to deliver our ethics presentation are Paul Saunders and Charles Kemp. Paul Saunders has been our go-to ethics partner for nearly 20 years. He has always provides thoughtful and considerate responses to any queries that we have, even when I call him multiple times a day. When he is not helping us figure out what end is up, he handles general corporate matters. Joining Paul for today's program is Charles Kemp. Charles is the chair of the Securities and Corporate Governance practice, which are also his major areas of client service. Welcome, Paul and Charles. Take it away.
Thanks, Jen.
Thanks, Jen.
One thing I'll say is we're going to be going through various case scenarios, and you can use the Q&A feature to try to get a question to us after each case answer. And if we have time, then we'll try to answer those questions right after the cases instead of at the end. Also, we'll try to use the chat feature to get answers to the questions that we're posing to see what y'all think about those. So with that, I'll start out with case one. And so this case is, during the 10 years that you practiced in a private law firm, you handled numerous real estate purchase and sale transactions, including at least 3 transactions in which your clients purchased former commercial sites from Pharmaco, a large drugstore retail chain. Last year, you withdrew from your law firm and joined in-house counsel or legal staff at Pharmaco. You just learned that your former law firm is representing one of your former clients in a breach of warranty claim against Pharmaco over asbestos contamination at the property that Pharmaco sold to your former client in the transaction that you handled. So the first question would be, do you have a conflict of interest if the general counsel tasked you with working on Pharmaco's defense in this matter? So go to the chat feature, and looks like we're getting lots of answers in. And it looks like most of the answers are coming in yes, Paul. So is that correct?
Yes, it is. And I'm relieved that there are so many people out there who are up on this rule. The relevant rule is 1.9, which deals with former client conflicts of interest. In my experience, conflicts arising from the representation of former clients are a distinct minority in all of the conflicts that lawyers and law firms typically have to deal with, but they're real and you have to take them as they come. Under Rule 1.9, a lawyer who formerly represented a client in a matter would have a conflict of interest if she thereafter represented someone else in the same or substantially related matter in which the second client's interests are materially adverse to the interests of the first client. Like as with most conflicts of interest, that is curable with informed consent from both the former client and the current client. With respect to the hypothetical, you first have to determine, is the prior real estate transaction that you handled with your former firm, is it substantially related to the breach of warranty claim now being made against your employer, Pharmaco? Comment 3 to the rule adds some color to the meaning of what is substantially related. Clearly, it's not the same matter. Matters are substantially related if they involve the same transaction or legal dispute. Well, that's easy. Or if otherwise there is substantial risk that information, note that it's not just information you obtained, but information that normally you would have obtained in the prior representation would materially advance the client's position in the subsequent matter. Now, the drafters of the model rules faced something of a dilemma in drafting this rule. They didn't want to put the former client who seeks to object to the representation of the subsequent client, didn't want to put them to the Hobson's choice of, I'll seek disqualification of my former lawyer, but I'm going to have to disclose the very information I'm trying to keep confidential in doing so. To avoid that quandary, the drafters of the rule came up with this concept of substantial relatedness. There isn't a precise definition for it, particularly once you get past the issues that are associated with the same representation. Best definition I've seen is that it arises from the same operative facts as the prior representation. Here, the issue that they're looking at is, did you acquire, or are you likely to have acquired information in the prior representation that would be material to your representation of the second client? Here, the reps and warranties that your current employer made in the purchase and sale agreement you negotiated on behalf of the purchaser are likely to be the central issue in this litigation. So I think there is little doubt that the two matters are substantially related. Besides that, in representing the purchaser, you likely were aware not only of what the purchaser knew about asbestos contamination, but also about its efforts at securing reps and warranties that covered that issue. And that may well become relevant in this litigation as well. Basically, yeah, it violated the rep, but you weren't misled, would be that sort of defense by the company. You have a conflict of interest, and as this is full-blown litigation at this point, you're not likely to get a waiver from the plaintiff.
Thanks, Paul. So could you even ask for the waiver in this situation?
It is, sometimes that is treated as a tactical matter by clients. That is, if you're engaged in contentious litigation, let's face it, what litigation isn't, do you really want to go to the other side hat in hand and seek to retain your counsel by asking for a favor from them? So often on that basis alone, the client will reject seeking a waiver from the other side. Arguably, it is a waivable conflict. Certainly, if the purchaser plaintiff were willing to waive it, the purchaser plaintiff would require that you be screened from the representation of Pharmaco. So you could have no involvement in it, nor could you communicate with your colleagues in the in-house staff about what you learned in the prior representation.
Okay. Well, I guess you can always tell your old firm that they aren't getting any work from you going forward, right?
Yeah, you could.
Well, let's go to case 2 then. All right, case 2. You are Associate General Counsel at Devco, a real estate development company. 10 years ago, before joining the company, you were a partner in a local law firm, and together with your firm colleagues, represented Sherman Paint Company with respect to its facility in an industrial section of the city. Testing revealed the existence of an underground pool of toxic substances deep beneath the facility. The contamination likely resulted from the use of neighboring property over 70 years before. Ultimately, your environmental colleague concluded that Sherman Paint had no remediation or reporting obligation with respect to the contamination, and that representation was concluded. Subsequently, Sherman sold the facility to Jackson Supply Company. Now, Jackson Supply wishes to sell the facility to your employer, Devco, and the president of the company has asked that you handle the transaction from the negotiation of the purchase and sale agreement through closing. So we'll open this up for questioning now. The question is there at least a potential conflict of interest because of your prior presentation to Sherman Paint? And again, use the chat feature to answer yes or no. Right, there are a lot of answers coming in, and I'll let them start to trickle off. All right, it looks like they're starting to slow down a little bit, and it looks like most, if not all of them, Paul, are saying yes, that there is a potential conflict.
And again, the majority has the right answer. This requires the application of Rule 1.7A2. Most conflicts under Rule 1.7 deal with the representation of one client adverse to another client. But under 1.7A2, there's also a conflict of interest if there's a significant risk that your representation of a client would be materially limited by your responsibilities to another client, a former client, a third person, or your personal interest. Your obligations under Rule 1.6 require that you keep confidential information that you acquired during the prior representation of the paint company with respect to this facility. That included any information that you gained regarding the pool of toxic goo underneath the property. That duty of confidentiality did not end when your representation of the paint company concluded, or even when you left the law firm. It goes on for as long as you live and thereafter. On the other hand, if you undertake the representation of your employer in this acquisition, you have a duty to do so zealously within the bounds of the law, which would include using available information that you have to advance DevCo's interests. Now, is this information material? The comments to the rule and the rule itself do not offer standards for materiality. I would suggest that if your client DevCo would not be willing to do the deal on the same terms and conditions, if it knew this information before it negotiated, as opposed to only learning about it afterwards, then that's the definition of materiality. I think it probably is material in this case, because upon learning it, I think it likely either that the company will decide not to purchase the property, or if it does decide to go forward, it will insist on stronger reps and warranties from the seller, indemnities, perhaps even an escrow of sales proceeds to back up the indemnity than it would have if it did not have that information. Now, there's an old New York City bar ethics opinion. I rarely cite New York City bar ethics opinions, but this was uncommonly sensible. It noted that no client has a legitimate expectation that its lawyer will use the confidential information of another client for the first client's benefit. The lawyer has a duty to use available information to advance her client's interest, but that's qualified by the duty of confidentiality to her other clients. A lawyer doesn't have the duty, nor does he have the right to disclose to one client the confidential information of another. They're general principles. Now, the New York City bar sort of posits two tests in this case. One it refers to as the materiality test, where information the lawyer has obtained and therefore is on his or her mind from the first representation is so material to the second that the lawyer can't avoid using it. The lawyer can be said to be representing differing interests in the sense that the representation of one client cannot be accomplished without violating the rights of the other. On the other hand, it can be said the lawyer is unable to proceed because continued employment will mean violating a disciplinary rule. That is, Rule 1.6, requiring the lawyer to keep confidential and not use the information of the first client for the advantage of the second. The second test is sometimes referred to as the independent professional judgment test. Remember, under 1.7A2, is there a substantial risk that the lawyer's representation will be limited by, among other things, his duty to another client? So here is the lawyer's exercise of independent professional judgment on behalf of the second client likely to be adversely affected by the lawyer's possession of information and the restriction on its disclosure or use. The issue is the lawyer, either one, is so concerned that first client will think that she traded on the information acquired in the representation, that she steers the representation as far away from the information as possible. If she does so, she is poorly serving her employer client in this purchase transaction. On the other hand, knowing the information and knowing that where it can be quote unquote discovered once again, the lawyer could be tempted to steer her representation of the second client so as to come upon this information by another way. Insist upon testing in a place where you wouldn't normally do so, that sort of thing. And when the lawyer does that, she is trading on the information that she acquired in the first representation and using it to the advantage of the second client. That's where the conflict lies. Now, there is an exception to this sort of conundrum, and I analogize it to the inevitable discovery exception to the warrant requirement under the Fourth Amendment. The confidential information you acquired in your prior representation would not be deemed material to your representation of your employer in this matter if it would be uncovered in the ordinary course of your representation of the company in the acquisition matter, unless it's important for the company to get that information earlier than it would have been obtained in the ordinary course. In this case, whenever your clients have acquired industrial property, your practice is to get phase 2 environmental testing. And you know to a reasonable degree of certainty that phase 2 testing will disclose the underground contamination you already know is there. So your possession of that information in advance isn't likely to affect your representation of the company, unless it's important that the company obtain that information sooner than you're likely to get the phase 2 testing results if you order them in the ordinary course. This is it's a pernicious kind of conflict of interest, I think, for two reasons. The first is it's next to impossible to imagine policies and procedures that a company or a law firm would put in place that would give you reasonable certainty that you would discover this conflict. You don't have a database listing just the material issues that you or material information you gained in a representation, and that flags it when that information becomes material to a representation of someone else in another matter. It's also pernicious because in many instances, it's impossible to get an informed consent from the client. Now, I say that just recently I've been assisting a client in negotiating an engagement agreement with, or an engagement letter with, a very large law firm. And that law firm actually has in its standard engagement letter that we may acquire information in other matters that could be material to our representation of you, and you hereby waive any conflict that arises from that. I don't think that most clients will relate well to a request from their lawyer to the effect that I know information from another matter that would be material to my representation of you. I can't tell you what it is. Will you consent to that? That just doesn't pass the straight face test, although apparently it has for this law firm that my client is dealing with. So that presents an awful issue because it seems to me informed consent is likely off the table there.
So Paul, just so I'm clear, if the phase 2 needs to happen sooner, or let's say the phase 2 comes back with an erroneous result and just misses the contamination, what can you do? You can, I guess, go to your former client and ask for consent to disclose it, but what if they don't give you that consent or will not give it to you?
Well, conflicts of interest can arise in any representation at any time. At that point, you're back in the soup. And it seems to me, absent consent from the first client, your only alternative may be a noisy withdrawal from the representation.
Okay. That could get kind of messy, I would think.
Yes, it is.
So going back, we did get a question on the first case that I wanted to ask you, Paul, and that was a question about whether or not the attorney that had come from the former law firm to Pharmaco and had represented the former client, in a matter against Pharmaco, whether or not they have a duty to disclose the conflict to Pharmaco.
Well, Pharmaco, in fact, should have asked when before onboarding them about matters that they handled, particularly matters that they handled with Pharmaco on the other side. They wouldn't have known about a conflict before they came on board because all they knew was they had a prior representation which had been concluded. So the conflict only arose when this claim is made after they're already on board. And at that point, the lawyer has a duty, as we'll touch on in the next hypothetical, along with the law firm to maintain procedures that are reasonably calculated to identify conflicts of interest.
Okay. All right, well, let's go to case 3 then. Excuse me. Assume the same facts as case 1 or case 2. Would the general counsel at Pharmaco or Devco, as the case may be, or any of your other colleagues be able to represent the company in the breach of warranty litigation or in the real estate acquisition without the conflict arising from your prior representation of the plaintiff or from the knowledge that you obtained during your prior representation of Sherman Paint? So we'll open this up for responses from everybody. What is your answer to that? There are a lot of answers coming in, and I'll let them keep trickling in for a second.
Looks like more no's than yeses.
That's what it's looking like. Quite a few yeses, but I think more no's. All right, it looks like it's come to an end. So Paul, what's the right answer there?
The answer is no. And it's a combination of what's known as the imputation rule and the very definition of what constitutes a firm or law firm. Under the imputation rule, Rule 1.10, while lawyers are associated in a firm, none of them may knowingly represent a client when any one of them practicing alone would be prohibited from doing so by Rule 1.6 dealing with confidentiality, 1.7 and 1.9, which is current and former client conflicts of interest, and 2.10E, which is a specialized type of conflict of interest involving a lawyer who formerly served as a mediator. Now, you might take the position that the imputation rule by its terms applies to law firms and not to the in-house legal staff of a corporation, but the rules define firm or law firm so as to include the legal department of a corporation or other organization. Comment 1A to Rule Point 10 adds a little extra color. As to law departments of organizations, ordinarily, there's no question that members of the department constitute a firm within the meaning of the rules. There can be uncertainty as to the identity of the client. For example, it may not be clear whether the law department of the corporation represents a subsidiary or affiliate, as well as the corporation by which the department is directly employed. Now, comment 3 to the concurrent conflict rule 1.7 also notes the rule requires that lawyers and law firms adopt reasonable procedures appropriate for the size and type of firm and practice to determine in both litigation and non-litigation context the parties and issues involved and to determine whether there are actual or potential conflicts of interest. So in-house legal organizations are required to adopt procedures designed to identify conflicts and potential conflicts, or at least those that they are likely to encounter. Most law firms, Williams-Mullen included, maintain, to begin with, a database. It includes the names of all current and former clients and all current and former adverse parties in matters that the firm or its lawyers have handled. You have to ask yourself, is it a good idea for in-house legal organization to have such a database? I think it is. What you put in it is another matter. Your list of clients is limited to the organization, and depending upon the particular portfolio of your in-house staff, all of the affiliates, some of the affiliates, it varies from organization to organization. I would suggest that certainly any matter previously handled by lawyers adverse to the company before they came on board with the in-house staff should be included in that database, so as to raise a red flag when you did a database check and a matter came up.
So a few questions here, Paul. The first one's a practical one that I had. And if the entire law department is conflicted out, I would presume that they would hire outside counsel to help with that. But practically, what involvement can the lawyers in the in-house counsel department play in that litigation with outside counsel? I mean, can they still direct it from a high level, or?
I don't think they can have involvement with it. They would need to be screened from that matter because they have a conflict.
Okay. And so that bleeds over to a question that we got from a participant. In law firms, we screen all the time, but I believe that occurs after we've gotten consent and the client has agreed to allow the screen. Is that the case, or can you cure the conflict with the screen?
Well, here you're disqualified. So you haven't cured the conflict. You've disqualified the law firm that is the in-house staff. Seems to me to guard against any allegation by the opposing party and its counsel that your in-house staff, notwithstanding the disqualification, is still involved in the representation. You would undertake to screen yourself to guard against or help defend against such an allegation. You are right that with respect to most conflicts, to cure the conflict, you have to have waivers, and we'll touch on that in a minute. Some of those waivers may be conditioned upon screening, but the screen alone doesn't cure the conflict. Here, we're not curing the conflict. The conflict caused the disqualification. Now we're just dealing with protecting ourselves, fireproofing ourselves, if you will, from allegations by opposing counsel that we're still involved.
Okay. And then my other practical question was for in-house counsel departments, do you know what might be considered reasonable procedures for them? Have you heard from people what they're doing in-house? Or is that kind of unsettled in Virginia?
I have not had those discussions with any in-house counsel. I may after this presentation, but not yet.
Okay, good. All right, well, let's go to case 4 then. All right, you were general counsel at Bosco, a food processing company, and you have an opening for lateral hire after the recent departure of a seasoned litigator in your office. A young litigation partner at a law firm in the region has contacted you about the position. After a round of interviews, you and your assistant GC agree that she is just the person you're looking for. You ask her for the information that you'll need to run a conflicts check and discover that she previously performed a limited amount of research in connection with protracted commercial litigation between Ajax Company, her firm's client, and your company, and that her work on such matter has concluded. You and several other in-house lawyers at Bosco have been involved with outside counsel in handling that same litigation. So the question is, would hiring the lateral candidate pose a conflict for you and your staff? Would the conflict be cured if you screened her from the representation of Bosco in the litigation with Ajax? If not, what do you need to do? All right, so again, use your chat feature. Looks like answers are coming in. All right, Paul, looks like quite a few yeses and a few nos in there as well. So,
Okay. And the answer to the first question is yes. Hiring her presents you with a conflict of interest that might disqualify you and all of your in-house staff from representing the company in the litigation. An ethics screen alone is insufficient to cure a conflict. You'll need waivers from Ajax and from the employer if you hire the lateral candidate. As I mentioned in connection with a prior hypothetical, often litigants are reluctant to ask for that kind of favor when they're in the midst of contentious litigation. So even asking may be off the table. Conflict arises under Rule 1.9 and Rule 1.10, or a combination of them. Again, 1.9 is the former conflict rule. If you formally represented a client in a matter, you can't represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the first client without informed consent of both parties. If you formally represented a client in a matter, or your present or former firm formally represented them, you won't use information relating to or gained in the course of the prior representation to the disadvantage of the former client. Now, there are competing considerations that inform this rule. The prior client needs reasonable assurance that the principle of loyalty to the client is not compromised, The rule shouldn't be so broadly cast as to preclude other persons from having reasonable choice of counsel. The rule shouldn't unreasonably hamper lawyers from professional mobility, from forming new associations, taking on new clients after leaving a previous association. And the comment recognizes, I would suggest it pays lip service to the notion that many lawyers practice in firms, that they to some degree limit their practice to one field or another, and that many move from one association to another a couple, maybe even several times in their careers. The comment actually notes that if the concept of imputation were applied with unqualified rigor, it would radically curtail opportunity of lawyers to move from one practice setting to another, and the opportunity of clients to choose counsel. Now, this lateral candidate would have a conflict if she were to join your in-house legal staff and work on the litigation. That is switching sides in the same matter. Even if she were screened and neither participated in the representation nor shared information with anyone else on the in-house legal staff about her former representation of Ajax in the litigation, the conflict remains. I would note that in the last 30 years, the Virginia State Bar has presented LEO proposals to the Supreme Court of Virginia 3 different times that would have permitted in limited circumstances the curing of a conflict by the imposition of an ethics screen. And the Supreme Court of Virginia rejected every one of those opinions. So there is no curing a conflict without informed consent. The informed consent may in turn be conditioned on screening. Now, you don't get there just with Rule 1.9. Rule 1.10 sort of magnifies the effect, as the lateral candidate would now be with your in-house staff, while lawyers are associated in a firm, read in-house staff. None of them shall represent a client when the lawyer knows or reasonably should know that any one of them practicing alone would be prohibited from doing so. Put another way, conflict follows the associate to your company and then is imputed to you and all of the other lawyers in your staff, much like a virus, all right? The only way to hire her and avoid disqualification is to seek and obtain waivers from Ajax and Bosco that would waive the conflict, but require that she be screened from participating in the representation of the company in the litigation and from sharing information that she gained in her prior representation of Ajax.
So I guess the other alternative is to not hire her until after that matter is concluded, right?
That's correct. And in fact, the next a couple of cases later, we'll get into that in more detail.
Okay. All right, well, let's go to case 5 then. Assume the same facts as case 4, except that instead of having previously worked on the litigation matter between Ajax and your company, Bosco, she has had no involvement in that matter. She had worked on a lease transaction in which her firm represented a lessor, Delta, and Bosco was the lessee, but the lease matter was concluded 2 years ago. You extend an employment offer to her. So the question now is, if she decides to accept the offer, will she, you, or the rest of the in-house staff be able to represent Bosco in the pending Ajax litigation without conflict? Looks like answers are coming in on the chat. Well, it looks like, Paul, that we've gotten kind of an even split between yeses and nos here.
Interesting.
Couple more coming in, but maybe a few more yeses than nos, but what's the answer, Paul?
And the answer is yes. This is a straight application of Rule 1.9. Remember, if you formally represented a client in a matter, you can't represent another person in the same or substantially related matter in which their interests are materially adverse without consent. And you can't use information acquired in the former representation to the disadvantage of the former client. But here, it doesn't apply because the lateral candidate had no involvement in the Ajax litigation when she worked at her current law firm. So she has no information that could be used to the disadvantage, material or otherwise, of Ajax in the litigation. The Ajax litigation and the former lease matter are wholly unrelated. So she's not acquired information during her representation of Ajax that would be material to the representation of Bosco in this litigation. Rule 1.9 doesn't apply. And since she has no conflict of interest, if she herself were to be assigned to represent Bosco in the Ajax litigation, there's no conflict of interest to impute to you or the other members of your staff.
That makes sense. All right, well, let's go to case 6 then. So assume the same facts as in case 4 and 5, except that the potential lateral hire not only performed prior research in the Ajax litigation, she has had substantial and ongoing involvement in that representation up to the present. So the question is, are there any other ethical issues associated with her pursuing employment with your company? Looks like the answers are already coming in on the chat feature. And Paul, it looks like that's going to be a pretty resounding yes coming in on this one. What's the answer?
And the majority is correct. Yes, there are other ethical considerations, a big one, in fact. Remember Rule 1.7A2. There's a concurrent conflict of interest if there is significant risk that the representation of a client will be materially limited by interests of another client, third party, or by the lawyer's own personal interest. A lawyer who pursues employment with a firm that she currently opposes in a matter may materially limit her ability to represent her current client, which would pose a conflict under that rule. There's an ABA formal opinion from 25 years ago, 96-400. And it notes that this sort of circumstance raises a number of ethical considerations. The lawyer's duty to represent her client without limitation imposed by her own interest under Rule 1.7, the duty under Rule 1.3 to act with reasonable diligence and promptness in representing her client, a duty under 1.6 to preserve confidentiality of information she gains during a representation that might be compromised by inadvertent revelations during the employment discussions, and the lawyer's duty under Rule 1.4 to keep her client informed about the matter and to communicate to the client facts pertinent to the matter. The implication being that the fact of her employment discussions may in fact be a fact pertinent to the matter. Now, there are two issues that affect the chance that a lawyer's pursuit of employment will materially interfere with the representation of her client and thereby pose a conflict of interest. What's the nature of the lawyer's role in the representation of the client? And what is the extent to which the lawyer's interest in the firm is concrete, has been communicated, and is reciprocated? It's likelier that a job search will affect the lawyer's judgment in considering alternatives or foreclosing courses of action if the lawyer has an active and material role in representing the client. On the other hand, if the matter is currently on hold for some reason during her job search. You've already tried the case, you've already argued it on appeal, you're just waiting for the appeals court to render a decision, and there's no further action to take or consider, then it's unlikely her job search at that time would affect the exercise of her judgment on behalf of her client, because there's no occasion for her to exercise her judgment on behalf of her client. By the same token, if the lawyer had a limited and now concluded role in the representation of client, there's no reason to think that the job search will prejudice the client's interest, even though other lawyers in the firm continue to represent the client in that matter. But the lawyer who is a lead lawyer in a matter shouldn't even contact the adverse firm about a possible association without consultation and consent from the client, because that contact might materially prejudice the client's interests. I thought that went a long way. So you can't even contact the firm to ask if, once this unpleasantness and litigation is over, might you be interested? I thought we'd done away with the appearance of impropriety standard when the rules of professional conduct were adopted and the old code of professional responsibility was superseded, but apparently not in this case. Now, what is the point at which the lawyer's interest in joining a firm satisfies the requirements that it be concrete, communicated, and reciprocal? There's no bright line. In most cases, between the extremes, either the lawyer with a minor and now concluded role in the client's matter at one end, or the lead lawyer for the client who seeks to switch sides on the other, the ABA opinion offers a little guidance. A lawyer who has an active and material role in representing the client in litigation must consult with and obtain the client's consent before she participates in substantive discussion of her experience, clients, or business potential, or the terms of an association with an opposing firm. So anything much beyond a general or an expression of general interest in talking further is likely to be characterized as a substantive employment discussion for purposes of that LEO. What does that mean as a practical matter for her? Well, it means she and the firm may have to defer employment discussions until the matter is concluded. In some situations, often in small towns, this can be a big problem when the nature of the lawyer's practice is such that she's likely to handle a succession of matters adverse to the company for the foreseeable future. You may have to look real hard for a window in between to have these discussions. There are circumstances where the lawyer doesn't have direct contact with the client, even though he or she is working on the matter. And it would not be appropriate or necessary for the lawyer to address the potential conflict directly with the client. The client would know who the hell he or she was. In those cases, the lawyer should disclose the potential conflict to the principal lawyer for that client or to the lawyer's supervisor in that matter, who then can choose whether to relieve the lawyer of further responsibility in the matter, at least during her job discussions, or to make the necessary disclosure to the client and obtain its consent to her continuing to work on its matter. The disclosures of the client should include all of the facts that the client needs to make an informed decision. What's the case posture? What's the nature of the work the lawyer has been doing and would be doing? And what's the availability of others in the firm to assume that the work that she is doing if she is assigned to do other work? In those cases, the law firm, in this case, the corporation, has an obligation to make disclosures to its client and obtain the client's consent. The obligation arises when the firm's interest in hiring the lawyer becomes sufficiently intense to raise a question that such interest might materially limit the firm's ongoing representation of its client in any of the ways mentioned above. The client should be consulted about the risk of disqualification where it's a litigation matter. which could involve not only losing its client in the middle of the matter, but also the expense of litigating the disqualification issue. And the firm should obtain the client's consent early on before the firm engages in substantive discussions of the experienced client's business potential or terms of association of a lawyer whose arrival could be a disqualifier. For many young lawyers looking at making a lateral move, just the prospect of going to talk to the boss about the fact that he or she is about to have discussions with in-house staff at a place where she's interested in being hired, or at another firm that's on the other side of a matter they're handling, is enough to cause them to suggest that we defer discussions until that matter is concluded.
I can imagine so. We did get a question in, Paul, that goes back to case 5. And in that case, the lawyer was involved in prior litigation before going or considering going to a new company. What if they had just been hearing through water cooler talk information about the matter before they went over, but weren't actually...
The focus of the rule is on protecting the former client's information. So even if you weren't assigned to the representation, if you nonetheless acquired information around the water cooler that would be material to the representation of the company where you seek to go and join in-house staff, the same problem arises, and it's a conflict of interest.
Okay, that makes sense. All right, let's go to case 7. Looks like we're getting close on time, but we can get this one in, I know. So case 7, you are in-house counsel for a corporation that is a defendant in a product liability suit. You hire an expert witness to testify on the applicable standard of care. You instruct him not to have any communication with the plaintiff or his lawyer. Is your instruction permissible? Again, use the chat feature to answer that. Is that instruction permissible? Paul, it looks like mostly yeses.
And the majority is correct. The answer is yes. This is the hypothetical addressed in a Virginia legal ethics opinion a couple of years ago, number 1787. Describes the duty of a lawyer when providing confidential information to an expert witness. Now, this arises under Rule 5.3a. When you retain or employ or are associated with a non-lawyer, you need to take precautions. It applies not only to employees of the attorney, but also to independent contractors such as this expert witness, and would direct the attorney to make reasonable efforts to ensure you have in place measures designed to give a reasonable assurance that the independent contractor's conduct complies with the professional obligations of the lawyer. Comment 1 to that rule confirms that Rule 5.3 applies not only to attorneys, but to independent contractors. The attorney in this instance has provided confidential client information to the non-lawyer expert witness. The attorney then needs to make reasonable efforts to ensure that the expert witness understands the attorney's duty of confidentiality and to ensure the expert witness protects the confidentiality of the information received. The specific questions in the hypothetical inquired whether the attorney could request the witness to contact the attorney if he received a request or subpoena for the client information, and obtain an agreement from the witness that he will keep the client information confidential, including not disclosing it to opposing counsel. Each of those steps would be appropriate for that attorney to ensure, as required by the rule, that the expert witness does nothing to compromise the lawyer's duty to protect the confidentiality of the client's information. Now, you have to read that rule in conjunction with Rule 3.4. And Rule 3.4 may be what some of those who answered no were thinking of here. It makes it unethical for a lawyer to request a person other than a client to refrain from voluntarily giving relevant information to another party, but it contains exceptions. One, the information must be relevant in a pending civil matter, certainly providing confidential client information to the expert witness meets that standard. Two, the person in a civil matter is a relative, a current or former employee, or other agent of the client. Certainly that fits the expert witness, and the lawyer must reasonably believe that the person's interest won't be adversely affected by refraining, and they would not.
Great, Paul. That makes sense. It does not look like we're going to have time to go to the next case, or to get to the other cases that are in the book here. I would encourage people to at least look at case 8. It's one that's close to my heart with SEC rules implicated on, and ethical duties intertwined with each other. So for any public company in-house person, I would definitely take a look at that question. But with that, I know that we're at a break time, so I'd like to thank everybody for coming, and thank you for your time. Thank you for joining us. And as you head into the break, after the break at 1:45, you'll hear from my partners, Chuck James and Chris Skinner, who will discuss government investigation trends and corporate compliance best practices. Again, thanks everybody.
Thank you.